Good afternoon, and thank you for joining us. Always a pleasure to welcome Laura Bramnick from TalkRealEstateAZ.com. That's the website, TalkRealEstateAZ.com. Laura is an attorney and a consumer advocate, and she can help represent people in negotiations for residential, commercial, and land transactions. Laura holds an active Arizona real estate license. She's been an active real estate investor, and she is a certified instructor with the Arizona Department of Real Estate. For more information, visit the website, TalkRealEstateAZ.com. You can also call Laura at 480-624-2705. 480-624-2705. Laura, good afternoon.
Good afternoon, Sinclair.
I mention on a regular basis that you help people negotiate real estate transactions.
Yes.
As an attorney, you can do that as part of the real estate transaction.
Yes, if you're buying property or selling property, if you're a landlord or a tenant, all those things are negotiations.
And negotiation is really kind of an art form in a way.
Yeah, now those negotiations usually you don't run into a lot of animosity. The negotiations where you run into more animosity is when something's gone wrong and one party feels that they are owed damages by the other.
But if you don't get the negotiations down in the first place, that can lead to problems later on that can result in animosity.
Yes, and you know, you and I have talked about this a lot in trying to anticipate what issues could come up or exit strategy. And most people are a little too lax about those issues, and then when they do come up, the emotions are high, and when your emotions are high, sometimes you lose your ability to negotiate in a reasonable manner, you know, because you get your emotions all tied up in the issues. And you know, the best negotiations occur when you can really clear your emotions and see what's going on. And even when you deal with mediation is a form of negotiation, except the mediator's job is to listen. You know, what is the person trying to tell me? What is the goal here? Because you may assume that the person wants a lot of money, but the person may want something else, and you're not really listening. So negotiation is definitely an art, and a lot of it not only has to do with listening, but it also has to do with the ability to read people.
So you really have to understand what the damages truly are.
Yes, you know, most of the time it is money, but not always. And I'm sure everybody listening can relate to that. There's sometimes that you want something else because the money is not going to make it right. You
mentioned mediation. Many cases, when there is a breach, go to mediation.
Yes, certain courts actually require mediation. And mediation's become very popular as a form to settle differences because it's less adversarial than other types of settlement conferences and negotiations.
Is mediation required?
It can be required. In other words, if I have a client that is accused of breaching a real estate contract, before the injured party sues, the real estate contract, the AAR contract that I talk about a lot, requires mediation. So you can't sue till you've gone through that process. Doesn't mean you have to settle, but you have to at least go through the process.
Given it a shot.
Given it a shot.
And really, you probably do want to stay out of court if you can.
Court is incredibly stressful and very, very expensive. It's time consuming, and it just requires a lot of preparation, and not only attorney's fees, but you're talking about possible expert witnesses, you know, an accountant, a contractor, depending on what the issue is, and all those people have to be paid fees in addition to your lawyer, plus time lost from work. And remember that your letting either a judge or a jury who doesn't know anything about you decide the fate of your case.
And there are no guarantees in court.
And there are no guarantees, and what a judge or jury sees as important may not be what you see as important. And sometimes, especially in the case of a jury, sometimes a jury can react emotionally. They may like or dislike something about you that helps you win or lose that case. And so you have to be willing to take those risks. And usually, if you can take more control during the negotiation process, you'll be happier with the outcome.
So generally, it's best to go with some sort of a settlement out of court.
Yes, but you want to prepare for that. You want to do your homework and get all your evidence together and talk to your witnesses and really take it seriously enough to say, okay, I think I deserve X in terms of a settlement, and I want to make my case strong so that it's likely that the other side will not want to challenge me on it.
If I receive an offer in a settlement, do I have to take it?
No, you do not have to take it.
I can still go to court.
You can still go to court. However, there is an Arizona statute that says that if you receive an offer in a breach of contract action and it's more than you ultimately get by the judge or the jury, then you have to pay the opposing party's attorney's fees, even though you came out with an award.
Oh my.
Yes, and people don't realize, because they just say, I can go to court, I need to have my day in court. But they're taking a risk when they do that.
That is certainly a motivating factor.
Yes.
A lot of things come up when it comes to negotiations. You've handled a lot of negotiations, and maybe we'll continue this conversation next week and take a look at your philosophy to approaching negotiations and what types of cases you handle as well.
That sounds great.
If you'd like to talk to Laura Bramnick, if you have something that needs a skilled negotiator, talk to Laura at talkrealestateaz.com. That's the website, talkrealestateaz.com. And the phone number, 480-624-2705. 480-624-2705. Thank you, Laura.
Thank you, Sinclair.